Szanowna Pani Minister,
Kedves miniszterasszony, kedves direktor úr, kedves hölgyeim és uraim, üdvözlöm! Jó napot kívánok Önöknek! A negyedik, utolsó panelt kezdjük el, ami összegezni fogja a nemzetközi lengyel-magyar kutatóplatformot, amit 2021-ben hoztunk tető alá az IVS helyszínén. Két felszólalónk van itt velünk a teremben, dr. Katarzyna Zombori és dr. Veres Emőd személyében. 4 felszólaló csatlakozik hozzánk majd online. Kedves hölgyeim és uraim, Artur Mezglevski professzor úr előadásával kezdjük, aki a bíráskodás és a bíróságok hatékonyságát, mint feladatot tűzte ki zászlajára. Még azt szeretném elmondani önöknek, hogy a professzor úr helyett én vezetem majd ezt a panelt, ennek a panelnek én leszek a moderátora, és kérem a felszólalókat, hogy nagyon tartsák magukat a megadott időkeretekhez, mivel itt Varsóban eléggé komoly közúti problémák adódtak az időjárás okozta kellemetlenségektől, és nem szeretnénk, hogyha a magyar kollégák lemaradnának. Nagyon szépen köszönöm. Én körülbelül felére le fogom csökkenteni a felszólalásomat. Tehát az én kutatásom célja az eljárási ügyiratok elemzése volt megbízhatóságuk és hatékonyságuk szempontjából. Az igazságszolgáltatás hatékonyságáról szóló közös projektunk részeként úgy döntöttem, hogy megvizsgálom, hogyan alkalmazzuk a kódex eljárási normáit a bíróságok és más eljárásvezető szervek által, elsősorban a büntetőeljárásra és a szabálysértésre és a szabálysértési eljárásra összpontosítva, amelyet ugye Lengyelországban külön törvények szabályoznak, mert van külön büntetőeljárási törvénykönyv és szabálysértési eljárási törvénykönyv. 146 eljárást elemeztem, 85 lengyel körzeti és regionális bíróságon folytatva. Megvizsgáltam, mi befolyásolja az eljárás során fellépő zavarokat, és hogy hogyan lehetne ezeket javítani. Azt vizsgáltam meg, hogy a bírósági eljárások tisztességének eljárási garanciái mennyire hatékonyak a gyakorlatban. Az eljárások hatékonyságának vizsgálata során különös figyelmet fordítottam azokra az ügyekre, amelyek a büntetőeljárás lejártának következtében nem zárultak érdemi határozottal. Azonban van egy nagyon élő gyakorlat, hogy a büntetőeljárásban ugye az ügyészségnek milyen szerepe van a rendőrség vezetésében. A rendőrség, mint egy ilyen előkészítő szerv, mind a bírósági ügyészként határozottan nem felel meg az elvárt normáknak. Ez a tevékenységek hatékonyságára és megbízhatóságára vonatkozik. Az előkészítő eljárások még kisebb jogsértések esetén is általában több heteket vesznek igénybe. A jelenlegi eljárások nagy mértékben felelősek ezért a helyzetért, ezért kutatásom eredményeként publikálásakor többek között a következő de lege ferenda következtetéseket javasoltam e tekintetben. A bűncselekmény elkövetésével gyanúsított személy kihallgatására vonatkozó kötelezettségek abszolútnak kell lennie, feltéve, hogy az érintett személy hajlandó alávetni magát a kihallgatásnak, és az érintett személyt kötelezően tájékoztatni kell ugye a 7 napon belül írásbeli magyarázat lehetőségére. A büntetés kiszabására irányuló kérelem elkészítéséhez elegendő személyes adatnak csak a vádlott kereszt- és vezetékneve, az úgynevezett PESEL-szám, az a személyi azonosítószám, ha van ilyen, a lakóhelye és kézbesítési címe, valamint a hasonló bűncselekmények vagy bűncselekmények miatt korábban ítéletekre vonatkozó információk tekinthetők. A rendőrök csak a statisztikákért felelősek. A rendőrségnél nem vezettek be eljárásokat az eljárási határozatok helyességének ellenőrzésére. A rendőrök munkájának értékelésénél csak a kiszabott bírságok száma, a bíróságra beküldött büntetési indítványok száma, az elkobzott vagy hát elvett vezetői engedélyek száma számít. Az incidens körülményének alapos kivizsgálása során fontos, hogy ki az elkövető. Az ilyen helyzetek gyakran olyan analízisekhez vezetnek, ahol az alábbi formális és javítást igénylő dolgokat vettek észre. Például egy nem megfelelően megformált jogszabály, aki nem az eljárás jognak megfelelően lett megfogalmazva, vagy a büntető eljárási törvénykönyv 422. cikkének második paragrafusából eredő szerencsétlen megoldás, amely oda vezet, hogy egy formai követelményt az indoklás terjedelmének megjelölésére, az ítélet indoklására nyújtó kérelemben nem szerepeltettek. A fenti jogalkotási hiányosságok miatt a szabálysértési eljárások általában 3, illetve 4 hónappal elhúzódnak. Tehát nem szabadna megindítani a távoltartási eljárást olyan helyzetben, amikor a gyanúsított vitatja a bűnösségét. Továbbá, a büntetőeljárási törvénykönyvnek az elsőfokú ítélet indoklásának terjedelmére vonatkozó kötelezettségre vonatkozó rendelkezésére inkább fakultatív, mint kötelező jellegű kell legyen. Az eljárások igazságosságával kapcsolatos kutatás során a joghatósági szakaszban elsősorban úgy elemeztem a garanciák hiányát, hogy megnéztem, hogy kinek, vagy kifelé kellene betenni, vagy kifelé kellene benyújtani az eljárásra vonatkozó indítványokat. Ez persze analogikus módon az ügyészségen történik. Nyilván a rendőrség által látjuk, a rendőrség szervezeti egységének vezetője, vagy az általa felhatalmazott más tisztviselő dönt, ugye mérvadóan arról a szeméről is, aki ellen büntetőindítványt kell benyújtani. Ez történik, ahogy már említettem, az ügyészségen is. A bírósági eljárásokban az ügyek főként személyes bizonyítékokon alapulnak. A bizonyítékok értékelése során a bíróság egyes forrásoknak hitelt ad, de ez alól a szabály alól csak akkor van kivétel, ha a vádlott bizonyítja az ártatlanságát. És ezt a bizonyítását, az ártatlanság vélelmének elvét a lengyel bíróságok joggyakorlatában nem fogadják el. Olyan elsőfokú ítélet elleni fellebezés esetén, amely bizonyos bizonyítékoknak való úgynevezett hitelt érdemlő helytálláson alapult, a másodfokú bíróság mindig helyben hagyta az ítéletet. Az ilyen ítéletek indoklásában általában a következőket olvassuk. A bizonyítékok értékelése az érdemi bíróság feladata, mivel az érdemi bíróság miután közvetlenül meghallgatta a tanúkat és megkapta a vádlat magyarázatát, jogosult arra, hogy a személyes bizonyítékok egy részét hitelt érdemlőnek tekintse. Végezetül szeretném hozzátenni, hogy véleményem szerint a jelenlegi szabályozásból nem következik, hogy az eljáróbíróságnak bármilyen joga lenne arra, hogy megválassza a tényeket, amelyekre az ítéletét alapozza. A bíróságok számára bitorlás, ha ilyen jogot tulajdonítok maguknak. Nagyon szépen köszönöm a figyelmüket.
Szanowny Panie Profesorze, bardzo serdecznie dziękujemy za
Kedves professzor úr, nagyon szépen köszönjük, hogy ilyen eszenciálisan megragadta ezt a problematikát, mivel tudjuk, hogy hónapokon keresztül ugye ezzel a tematikával foglalkozott, és mivel ismerem a professzor urat évek óta, tudom, hogy ön egy nagyon konkrét személy, és nyilván néhányan órákon keresztül beszélnénk egyes témáról, de tudom, hogy ön percek alatt el tud annyira eszenciálisan és annyira lényegre törően elmondani gyakorlatias nézőpontokat, és annak esetleg gyakorlatba való bevitelét vagy beemelését a joggyakorlatba. A következő előadónk Marcin Rau lesz, aki című előadást fogja megtartani. Kedves Marcin, hallgatjuk.
Thank you very much. I wish I could be with you today, exactly like Dr. Rafał Wielki. I declared my willingness to participate in person. However, unfortunately, I got sick and we are connecting online. At the very beginning, I would like to thank the organizers for excellent coordination of this event and also for the opportunity to conduct my research. It's been an extraordinary pleasure for me and great adventure to be part of such a project and meet so many outstanding researchers. Much appreciated. So, as always, I will try to be as precise as possible and to present my most important conclusions of my research in the most interesting way I can. So let's get started. At the very beginning, I would like to remind you what I studied. It was the influence of human factor on the effectiveness of criminal proceedings. But what actually is this human factor? These are the all aspects that have an impact of criminal process and are not related to the rules of procedure and cannot be changed by amending the criminal code or code of criminal procedure. These are all behaviors of us people who conduct criminal proceedings, from the moment of committing a crime to the conviction of the perpetrator of crime, of course. These are the elements, the way we operate, manage work, manage people, organize work, work environment, and the tools we use for this purpose. But what is also very important, there are also psychological elements. So how we deal with stress, with emotions, with procrastination, how we interact with other people in our workplace. I ask the question, what influence do these elements have on the speed and quality of criminal proceedings? In order to answer those questions, I conducted a survey on selected focus group of 80 judges, attorneys, and prosecutors who participate in criminal proceedings. So let's present the conclusion. Firstly, let me show the typical psychological profile of each group. My research has shown that attorneys are the most creative group. They like to improvise. They looked for alternative solutions. They don't give up their arguments. They also have problems in doing their task on time because they tend to postpone their duties until the last minute. Prosecutors are the complete opposite of attorneys. They don't like procrastination. They prefer careful planning ahead. They are more pragmatic than creative. And what can be a surprise? They look for compromises in discussions. Judges, on the other hand, are some kind of mix of attorneys and prosecutors. They don't like to plan carefully. They are almost more pragmatic than creative, but they like to argue. Like attorneys also do they also do things for the last moment, for the last minute. So they also have problem with procrastination. But despite these differences, there are some common features of all groups. There are 3 issues that all 3 groups agree. The first one is the staff shortage. Each of the respondents admitted there are too few employees in the office, which means that everyone has too many tasks, but not meritorical tasks, but also administrative tasks. Work overload and deadline stress negatively affect efficiency. But while attorneys can hire employees whenever they want, as much they want, and how they want, filling the positions of judges and prosecutors is complicated because full of formalism, full of unnecessary bureaucracy. Everyone agrees the number of judges and prosecutors is too small, and this is an important problem. The next factor is the quality of legal studies. Everyone agrees that in the current formula, legal studies don't provide practical knowledge. The didactic model is outdated and doesn't meet the requirements of working in the judiciary in any way. All respondents state that they have to gain knowledge by themselves, and only the application after studies can help them. It means that during the 5 years of legal studies, the acquired knowledge doesn't allow to work in the profession. Can we imagine a medical doctor, engineer, or architect having a similar problem after 5 years of studies? 5 years of, for example, medical studies, and the future doctor says he cannot work in his profession? No, it's unbelievable. But this is the case with the attorneys, prosecutors, and judges. Legal studies require, therefore, a radical redefinition in order to focus on the practice. And the last element, which I'd like to focus are the soft skills. Because even the best expert in the field will not speed up the proceeding if he cannot talk to people. Personal management, work management, and persuasion skills are key skills. All respondents agreed that such kind of skills should be taught during their studies because they significantly facilitate the work and positively influence the effectiveness of work. To sum up, my research showed that the human factor is underestimated by the legislator, but it plays a huge role in the efficiency of court proceedings. Not changing the regulations and not changing the procedure will speed the proceedings, but changing the model of education of future lawyers and using the already existing human capital, human factor, because every year thousands of young people graduate from law school. And the role of the state is to see them because they can be the rescue for the judiciary and positively impact the effectiveness of justice. Thank you very much for your attention and thank you for having me.
Thank you very much. Dziękujemy bardzo.
Nagyon szépen köszönjük az előadást, és hogy sikerült meghosszabbítani az előző előadást, a témát továbbvinni, kiszélesíteni a büntetőjog témáját, és különböző aspektusokból megfigyelni itt az igazságszolgáltatás, mint a büntetőjogi szakértő, a professzor úr rámutatott több olyan szempontra, mert javíthatná az eljárások hatékonyságát. Köszönjük szépen, annál is inkább, hogy a doktor úr nem tud megtenni, hogy audio és videó kapcsolatot teremtsünk a professzor asszonnyal. Közben megkérjük közben dr. Emöd Veres urat,
zatytułowany Efficiency Requirement in Civil Justice Reform, Possibilities and Limits.
hogy akkor adja elő a prezentációját. Köszönjük szépen.
Thank you very much, and of course my words are of thanks for being accepted into this research group, and I also really like being here in Warsaw, so I decided to talk very long to miss the plane, and we can stay one more day at least in Warsaw. Using this method, I will share all my research, which I did regarding this very interesting topic, which is the efficiency of justice. From my point of view, efficiency of civil justice, because I am a private law specialist and not in criminal law. And in general, my underlying assumption of the research was that the efficiency of justice is a much broader concept than the speed of justice. Speed is only one of the factors of efficiency, but the justice must be characterized by the simultaneous application of several principles and values. Practically, this application in parallel of different values can lead to quality in justice. And speed cannot be absolutized as the defining principle of civil justice. So in the course of this research, I have addressed issues such are the principles which defines litigation, and also which reforms are ongoing or acceptable or must be refused in order to create a balanced system of civil litigation. But today I want to talk about a very specific issue in a close connection of my research. The effectiveness of justice depends in a large extent on the quality of law. And in this context, in my book chapter, I wrote in detail about a recent Hungarian reform, the introduction of the limited precedent system, which is some kind of experiment. And in the presentation of today, I would like to draw some background of my book chapter. I will talk about on issues which are not present in the written form of the article. What is in the essence the limited precedent system? The decisions of the Curia, High Court of Hungary, which formulates new legal doctrines, practically acquired the character of source of law because they are mandatory for the lower courts. So this is a precedent system in a civil law country. And of course, this reform is not without controversy, interpretation, and even political misinterpretation. So it is good to give some light into this problem. And the private law background actually is historical, because the first Hungarian civil code, it was adopted during the Soviet-type dictatorship. It is the Act 4 from 1949. And this is the first Hungarian civil code. And if we look from a comparative legal point of view, in this region, the other states had written codes. Just for example, Serbia had a written code from 1844. The newly created Romania had a written civil code from 1864. So but other states as well, the present-day Czech Republic, Croatia, Slovenia had the Austrian Civil Code in force. So all these countries use the written sources of law. On the contrary, in Hungary, it was in force a customary private law. And this customary private law actually was a real force of the society, and the whole 19th century and the first half of the 20th century, it was characterized by a tension between the two main groups, one group opposing codification and the other group in favor of codification. So this line of maintaining the impossibility of codification was very strong. And very renowned lawyers were in it. The professors and lawyers in favor of codification were the minority. And actually, if we want to characterize the situation, we can take the example of Benny Grossschmidt, who is regarded as the main legal thinker of Hungarian private law in all the times. So, about Benny Grossschmidt, the Professor Ferenc Mad, who gave his name to our institute, wrote that Professor Grossschmidt in the morning works on codification at the Ministry of Justice, and in the afternoon at the university they teach the ultimate impossibility of codification, denying what is doing at the Ministry of Justice in the mornings, because Professor Grossschmidt thought that codification is impossible because only an imperceptible historical process can lead to regulation, and this is the organic development of legal rules. So practically he played in both groups, but he believed in the anti-codification approach. What were the arguments in this context, pro and contra, very shortly, of the two opposing groups? The first issue was the timeliness. If codification is proper in that moment or not. Actually, very good quality project was ready at the turning point between the 19th and the 20th century. And that project had 5 variants, the last one in 1928. And that version was of original work of very high quality. But none of these projects were adopted. And the issue of timeliness was raised that for example, in the beginning of the 20th century and in the interwar period, there are so many changes in society, in economy, in general. There are ideological changes, social upheavals, economic crisis, and so on. And the opponents of codification said that we should wait to arrive in a less turbulent period, and then we can adopt a new code. On the other side, those who favor codification said that the reason to adopt a code is exactly that everything is in motion, and in those turbulent periods, an island of protection can be a code, written legislation. And the second issue, as it was mentioned before, it was that the persistence of the customary law was very strong. We cannot understand from today's view how strong it was. And practically they perceived, and mostly judges, for example, the president of the Curia of that time, they perceived the written codes like too rigid, and which makes difficult in application for the judge, because the case must be decided on the rule contained in written norm, and this is actually too rigid to compare to the complexness of life. So this approach was very strong, and of course the adepts of codification took the approach that rule of law and security of legal relations requires written norms. This was the contra argument. And third aspect which can be discussed is the permanent comparison to England, which is in this European region, the only parallel we can find with the old customary Hungarian legislation. And actually the opponents of codification used England as a positive example, which has it was perceived that in this period the mostly developed system of private law based on precedents, but the opponents of this approach in favor of codification, they said that English law is totally different, because in English law the judgment itself constitutes precedent. In Hungary, the judgment can only trigger a precedent or establish a way of thinking in the customary law. The judgment itself had no value as a legal source. And this debate was very, very fervent, and actually there is no way to know which would have prevailed, because the situation was that at the beginning of the Second World War was that the anti-codification position won. And the theoretical debate, which had incredible practical importance, was actually concluded outside the organic development. Codification finally in 1959 took place in the conditions of the Soviet-style dictatorship, when the essence and benefits of customary law could not really be realized. So this was the end of this debate, an artificial end, and now happens something new in this debate with this limited precedent system, and actually this is not a victory for anti-codification or pro-codification movement. It seems much more a compromise. On one hand, this is a recognition of the high usefulness of the codification of the written norms, but on the other hand, there is also a possibility of revival for customary law. And the code is perfectly accepted as a written norm today in Hungary, and having the certain level of abstraction give the necessary freedom for the judge to apply the legal norm to a certain case, but also the High Court can determine legal rules which are like precedents, not contrary to the written law, but giving that flexibility to the legal system which is necessary to have a unitary jurisprudence, to have a unitary case law, and of course to have an efficient system from the point of view of the quality of law. And this compromise, as I see, is very important, adds a lot to the flexibility of the legal system, and of course gives precedent for the substantial justice which is really needed. And finally, I see this reform as a sign of trust in the judges of the Curia, in the judges of the Hungarian Supreme Court. Thank you very much.
Köszönöm. Szanowny panie profesorze, bardzo serdecznie.
Kedves professzor úr, nagyon szépen köszönjük ezt az előadást. Amikor hallgattam a szavait, a következő gondolatok születtek meg bennem. Mindenek előtt közös gyökereink vannak, ami a polgárjogot illeti, ugye a római jog. Viszont ami az elméletet és a gyakorlatot illeti, szintén nagyon közel állunk egymáshoz. Fel tudjuk használni a kutatások eredményeit, amit ön bemutatott, és talán pontosan ezért volt ez az egész csapat munkája, hogy a magyar professzorok tapasztalatát is felhasználhassuk, ami a gyakorlatot illeti, és Grossmit professzor kázuszát. Lengyelországban is vannak szakértőink, akik képesek egymással szemben álló véleményt írni két megrendelőnek, úgyhogy ez nem csak egy magyar gyakorlat, hanem ismerjük, a technika nem engedi meg, hogy a professzor asszonnyal fölvegyük a kapcsolatot, úgyhogy megkérem Zombori Katarzyna doktorasszonyt, hogy mutassa be a kutatása eredményeit és a kutatása témáját.
Doktor, bardzo proszę.
Dziękuję bardzo. I bardzo bym prosiła o wyświetlenie prezentacji. Dziękuję bardzo. Dear organizers, dear colleagues, it is a very great pleasure for me to be here and to speak to such renowned and distinguished colleagues and guests. And I am very, very grateful for this opportunity. As you can see, the subject, the title of my presentation is The Right to an Effective Remedy, a key element for the effectiveness of the European human rights system. This was the subject that I dealt with during my research within the Polish-Hungarian research platform. And I would like today to briefly summarize my results and to share with you these results. However, at the beginning, let me start my presentation a little bit maybe unconventionally. Here you can see a set of pictures of Polish, Hungarian, and maybe international celebrities. I think that no one can argue with the fact that we witness an era of celebrities. By celebrities, I mean famous people who are highly visible in mass media, on the internet, who are very recognizable, and generally who receive enormous public attention. Probably anyone who uses internet or reads newspapers can name maybe one or two celebrities, either from their own country or from worldwide. Well, I dare to say that there are also some celebrities among human rights as well, like, for example, the right to the freedom of expression, or the right to peaceful assembly, or the right to equality. I call them celebrities because they are also very well known, well heard of and recognizable, even by laymen. people who are not lawyers. For example, these rights that I have just mentioned, they can be seen widely on posters during mass protests. Well, dear colleagues, the right to an effective remedy is definitely not one of the celebrities among human rights. I have never seen a poster or a photo of protesters demanding the right to an effective remedy. Maybe you have seen one. In that case, please let me know. I even think that maybe some of us lawyers would have some difficulties with placing the notion of the right to an effective remedy within the human rights protection system. And, please allow me for a little disclaimer. By using this slightly maybe provocative comparison with celebrities, I by no means wish to say that there is something wrong with the fact that some human rights are more recognizable than others. What I wish to say, however, is that the right to an effective remedy definitely lacks wider public attention, which probably it should be getting, as it is one of the most fundamental provisions for the entire functioning and effectiveness of the European human rights protection system under the European Convention. The issue of effective domestic remedies has been a long-standing concern of the Council of Europe, under the auspices of which the European Convention on Human Rights was adopted in 1950. The Committee of Ministers of the Council of Europe has adopted 2 recommendations in which it was stressed that there is a very close interdependence between the availability of domestic remedies and the effectiveness of the ICHR system. Also, the implementation of the European Convention on national level and its effectiveness was discussed at the higher political level, for example, during the high-level conferences on the future of the court, which were held in Interlaken, Izmir, and Brighton, and which led directly to the adoption of Protocols 15 and 16 to the Convention. More recently, during the high-level conferences in Brussels or in Copenhagen. In my presentation, I will try to explain to you the notion and the concept of the right to an effective remedy, then the requirements of effectiveness under Article 13. I will try to provide you with some typology of domestic remedies, and in the last part of my presentation, I would like to give you some examples of domestic remedies under Polish and Hungarian legal system, together with some conclusions. So, to start with the notion of the right to an effective remedy. This right, the right to an effective remedy, is regulated, is provided for in Article 13 of the European Convention on Human Rights. And let me read it out loud to you. It states that everyone whose rights and freedoms as set forth in the Convention are violated shall have an effective remedy before a national court, before a national authority, notwithstanding that the violation has been committed by persons acting in an official capacity. So, in other words, Article 13 provides for a procedural right to enforce at the national level the rights and freedoms as they are set out in the European Convention on Human Rights. It forms part of a more complex scheme, a more complex mechanism, which is aimed at securing the enforcement and implementation of the Convention. It rests upon the principle of subsidiarity, and it also includes the obligation of states to respect human rights, the obligation of states to execute judgments of the European Courts of Human Rights, and also the availability of domestic remedies. The principle of subsidiarity mentioned in the beginning, it requires that rights which are secured in the European Convention on Human Rights shall be available, shall be secured at first place within the national legal systems and applied by national authorities. And then, only then, individuals may seize the European Court of Human Rights. This principle of subsidiarity is also well reflected in Article 35, paragraph 1 of the Convention, which sets out the rule on the exhaustion of domestic remedies among the admissibility criteria for a claim. So, as you can see, these provisions, which aim at ensuring the practical effectiveness of the Convention, are intertwined. They work a little bit like communicating vessels. And definitely the right to an effective remedy plays an important role in this mechanism. If we take a closer look at the Article 13, we can see that there is no definition of a remedy or an effective remedy. These issues have been addressed in the case law of the European Court of Human Rights. According to the court, the effectiveness of the remedy does not depend on the certainty of a positive outcome for the applicant. According to the court, the remedy simply means an accessible remedy before a national authority, which is competent to examine the merits of the case, and not a remedy which is bound to succeed. According to the case law of the European Court of Human Rights, the primary requirement for a remedy is to be effective in law and in practice as well. And it suggests that domestic remedies shall be accessible, they shall be capable of redressing the harm, and they shall offer reasonable prospects of success. When we take a look at Article 13, we can see that its wording refers to the domestic authority when it says that everyone whose rights and freedoms have been violated shall have a remedy before a national authority. According to the European Court and to the wording of the Convention, the domestic authority does not have to be necessarily a court. Well, in determining whether a remedy is effective, the European Court of Human Rights takes into consideration the powers and procedural guarantees of a national authority, including its independence, together with the facts of the case and the nature of the rights at stake. And of course, it should be said that the best guarantees are always offered by courts. As we can see, the wording of Article 13 is rather vague and general. It does not give us any definition of a remedy or a definition of a national authority. It does not provide us with any requirements of effective remedy. And unfortunately, not unfortunately, it also does not give us any hint as to the particular type or form of a remedy which is required. States are given certain freedom, certain margin of appreciation in adopting national remedies. However, it should be kept in mind that the nature of the right at stake and alleged violation has serious implications for the type of remedy which shall be provided. These are so-called specific remedies, which are designed to give redress in case of specific violations of human rights. For example, remedies against the deprivation of liberty or against non-exhaustion of judgment, or for example, remedies against excessive length of proceedings. Apart from the right-specific remedies, states may also adapt so-called general remedies in for situations which cannot be dealt with right-specific remedies. An example of a general remedy is a constitutional complaint. Let me pass now to the part which deals with national regulations. In my chapter, this was a part which I elaborated upon in great detail. Here I hope to give you only a brief outline and comparison of national regulations pertaining to the right to a legal remedy. In Hungary, the right to a legal remedy is explicitly provided for in the fundamental right of 25 April 2011, together with other procedural guarantees stemming from the right to a fair trial. According to the Hungarian Constitutional Court, the protection afforded by the right to a legal remedy shall be actually enforceable and capable of redressing the harm. As we can see, it is the same standpoint and interpretation of the right to a legal remedy as the one of the European Court of Human Rights. By contrast, the Polish constitution does not provide explicitly for the right to a legal remedy. However, it can be implicitly derived and directly derived from other constitutional guarantees, like, for example, the right to a court or the right to appeal. Both countries, I mean Hungary and Poland, have adopted general remedies, constitutional complaint mechanism. The Hungarian constitutional law since 2012 provides for 3 types of constitutional complaint, which offers the possibility to challenge legislation and also the possibility to challenge individual judicial decisions, as Professor András Pátyi told us in his today's presentation. In turn, the Polish constitution provides only for the possibility to challenge legislation via the constitutional complaint and not individual judicial decisions. The European Court of Human Rights have dealt with Polish and Hungarian constitutional complaint several times. And generally, it has assessed that both Hungarian and Polish constitutional complaint is compliant with the requirements of Article 13. However, in some cases, the court has noted that there is room and need for improvement, both in case of Hungary and in case of Poland. To give you some examples of right-specific remedies, I have chosen the remedies against excessive length of proceedings. Mainly because it is one of the most popular issues raised in applications to the European Court of Human Rights, not only with respect to Poland and Hungary, but it is true that in Poland and in Hungary it is one of the most demanding challenges for the whole judiciary. Which is often due to structural problems, as also the European Court has observed, for example, due to the lack of financial and administrative resources or the lack of judges. Several Polish and Hungarian cases are currently pending under enhanced supervision before the Committee of Ministers of the Council of Europe, in respect with to criminal, civil and administrative cases as well. They include 2 cases which were ruled upon a so-called pilot judgment procedure. It was the case Gajra versus Hungary and Rutkovsky versus Poland, both judgments were delivered in 2015. After the Gajra versus Hungary case, the Hungarian legislator adopted 3 new codes of procedure, which all went into force in 2018. And it was the Code of Civil Procedure, Criminal Procedure, and Administrative Procedure. And each of this new code provides for some preventive remedies in order to accelerate protracting proceedings. It is the mechanism of a complaint about the excessive length of proceedings. Also, after the Gajra versus Hungary case, to comply with the judgment of the European Court of Human Rights, Hungary adopted a new law. It is the Law Act number 94 of 2021. It was adopted in June this year, which provides for compensatory remedies for the breach of the right to have a hearing without undue delay in case of excessively long civil proceedings. In case of Poland, the main preventive remedy for excessive length of proceedings is the complaint about the excessive length of proceedings. It is regulated in Act of 17th June 2004, which was adopted after the judgment in Kudła versus Poland case. And it was subsequently amended after the judgment in Rutkovsky versus Poland, in which the court identified several shortcomings of the Polish mechanism. So this Act of 2004, in its present form, it provides for the right to complain about the breach of the right to have a case examined without undue delay, in respect to civil, criminal, and administrative judicial proceedings. On one hand, this act is designed to give preventive remedies, and on the other hand, it is designed to give compensatory remedies. However, in this compensatory aspect, the Act of 2004 is not considered effective remedy by the European Court. It is due to excessively low amounts of compensation, according to the court, which is awarded by Polish courts. So, coming to conclusions, we can say that the European Convention of Human Rights gives us a system which shall be practical and effective, and not theoretical and illusory. For this reason, it is equipped with an enforcement mechanism in which the right to an effective remedy is of key importance, together with the principle of subsidiarity. If the Article 13 does not have full implementation, citizens, individuals will be forced to refer to Strasbourg cases, complaints which normally shall be dealt with within the national legal system. And in further perspective, it can threaten, it can jeopardize the functioning and effectiveness of the entire system of human rights under the European Convention. The bodies of the Council of Europe are in constant dialogue with the national authorities as to the availability and effectiveness of remedies, which takes place, in first place, within the complaint procedure before the European Court of Human Rights, and also within the supervision procedure of execution of judgments, which takes place before the Committee of Ministers. I use the word dialogue, but sometimes it seems to me it's like a ping-pong game. If we take a look at the supervision procedure, this ping-pong game takes place between the Committee of Ministers and national authorities, the agent of the state. And I've taken a look at the documents which were submitted by Poland and by Hungary. And I think that Poland and Hungary gives a good example of how this dialogue, or ping-pong game, if you wish, works in practice. However, I think that Madam Secretary of the State, Dr. Anikó Reis, probably is far more competent to speak about these issues. I believe it is her daily bread. But what I try to look for, what I've tried to show you within the chapter of my book, within the book chapter, or in my presentation, is that this dialogue led to some substantial changes in the domestic legal environment in Poland and in Hungary in terms of the excessive length of proceedings, and hopefully it led to a better level of protection of human rights. Thank you very much.
Dear Dr. Zobor, thank you very much. It was very interesting ping-pong dialogue or implementation, yeah, because we have a Strasbourgian standard of human rights, and we try to implement this standard to our legal system. It's not easy. When I wrote sometimes the information from Strasbourg, I thought, thank you, God, I haven't heard. Okay, thanks so much. Przepraszam, miałem mówić po polsku.
Elnézést, úgy volt, hogy lengyelül beszélek, de már így átálltam az angolra ebben a környezetben. Akkor a harmadik próbát most megtesszük, hogy felvegyük a kapcsolatot Anna Tunyával. Kérem akkor a professzor asszonyt. Remélem, hogy most már hallható vagyok, elnézést kérek a problémákért. Az én kutatásomnak a témája a kontradiktórius elv és nyilvános eljáráshoz való jog elvének megvalósulása, mint a hatékony és igazságos eljárás meghatározója. És a gyakorlatot néztem, illetve a jogi előírásokat, hogy megnézzem azt, hogy az emberi tényező mennyire befolyásolja ezeket a folyamatokat, a eljárások hatékonyságát, és ezt szeretném bemutatni ennek a kutatásnak az eredményét, a kontradiktórius elv és a nyilvános eljárás szempontjából. Ezek nagyon széleskörű kutatások voltak, úgyhogy szeretném bemutatni röviden a legfontosabb eredményeket. Ami a megvalósítást illeti, a kontradiktórius elv megvalósításában, így itt a vádló és a vádlott oldala jelentkezik. Főleg itt a szabálysértési perrenddel foglalkoztam, hiszen főleg ezre koncentrálódik a munkám, mint ahogy a polgárjogi ügyekre. Itt a szabálysértéseknél, illetve és a büntető jognál, ugye a vádlónak egy aktív szerepe van, neki kell bizonyítania a vádlottnak a bűnösségét, a vádlott pedig egy passzív oldal, neki nincsen kötelessége, hogy bizonyítsa a sérthetetlenségét. A vádlott és a vádló szerepét ugye a jogi előírások határozzák meg. A vádlónak kell összegyűjteni és bemutatni azokat a bizonyítékokat, melyek a vádlottnak a bűnösségét igazolják, és közben a vádlottnak kell erre reagálnia, ezekre a bizonyítékokra. Hogyha összehasonlítjuk az előírásokat a gyakorlattal, akkor láthatjuk azt, hogy a gyakorlatban teljesen máshogyan néznek ki ezek a szerepek az eljárás során. Ez főleg akkor érzékelhető, amikor szabálysértési eljárásokról beszélünk, és már a eljárás előtti folyamatban a közvádlónak a szerepe gyakorlatilag csak arra korlátozódik, hogy egy indítványt nyújtson be a bírósághoz, és illuzórikus bizonyítékokkal támaszza csak alá. Hangsúlyoznak kell, hogy rossz gyakorlat az, egy nem megfelelő gyakorlat az, hogy ezekben az indítványokban nincsen magyarázat, nincsen indoklás, és ez nem a jogi előírásokból, a szabálysértési kódexből adódik, és ez egy komoly hiányosság ebben a procedúrában, mely új szabályozást igényel. Hogyha tovább nézzük már a bírósági eljárás folyamatát, a vádló aktivitását szabálysértések ügyében, akkor a gyakorlatban úgy néz ki, hogy a vádlónak nem vesz részt az adott üléseken, tárgyalásokon. A vádló gyakorlatilag csak az első tárgyaláson van jelen, ahol felolvassa az indítványát, de nem indokolja meg, ahogy ugye már ezt említettem, és ha jelen van a bizonyítási eljárás során, és valamilyen bizonyítékokat mutat be, akkor általában nincsenek megállapítási tézisek, vagy milyen fajta körülményekre hivatkoznak ezek a bizonyítékok. Hogyha a közvádló jelen van a tárgyaláson, ahol ugye egy záróbeszéd, vagy egy védőbeszéd jelenik meg, akkor ez egy ilyen nagyon lakonikus záróbeszéd, mely általában egy mondatból áll, hogy a vádló indítványozza a vádlottnak a megbüntetését. És a levezetett kutatások megmutatták azt, hogy az aktivitás része a folyamat során főleg a vádlottra hárul, tehát a vádlott és az ő védője kötelezett arra, hogy olyan bizonyítékokat, olyan tényezőket keressen, mely a bűnösségét, a büntetlenségét bizonyítja. Minden egyes nem megjelenés, hogyha egy tárgyaláson nem tud megjelenni, kötelező jelleggel ugye igazolást igényel. A tanúk felé irányított kérdések indoklást igényelnek, hogy mi a célja ezeknek a kérdéseknek. Tehát ami a kontradiktórius elvet illeti, ez egy hiányosan alkalmazott elv, és szükség lenne megfelelő újabb szabályzásokra, melyek a vádlónak a szerepét reformálnánk, és azoknak az előírásoknak a betartását, mely megjelennek a szabálysértési kódexben, melyek indikálják azt, hogy az indítványnál igenis meg kell indokolni az adott indítványt és a bizonyítékokat, illetve igény lenne arra, hogy a bíróságok igenis követeljék a vádlótól ezeket az indoklásokat az indítványok beadásánál. A kutatásaim során foglalkoztam a büntethetőség időben való lejárásával, ami a szabálysértéseket illeti. A szabálysértési kódexben megtaláljuk azt a pontot, hogy akkor évül el az adott szabálysértést, hogyha a szabálysértésről számított egy éven belül nem kezdődött el eljárás. Hogyha ezt elemezzük, ezt az előírást, megnézzük ennek a hangzását, akkor megállapíthatjuk, hogy nem értelmezhető, nem olvasható, és ezáltal kétséges az, hogy megfelelően interpretálják-e, hiszen az elévülés, a szabálysértés elévülése gyakorlatilag 2 év után valósul meg, miközben a szabályalkotónak, a jogalkotónak egy 3 éves ciklus volt a célja. Tehát ezért korrigálni kell a szabálysértési kódext ezen pontját, melynek az lenne a lényege, hogy ebben az előírásban, ebben a pontban, hogy az elévülés 1 vagy 3 éven belül, tehát az elévülés ideje 1 vagy 3 éven belül keletkezik a szabálysértés elkövetésétől, függően attól, hogy elkezdődte az eljárás vagy nem.
Zgodnie z artykułem 59, paragraf 2 Kodeksu postępowania w sprawach o wykluczenie.
Ha visszatérünk a szabálysértési eljárási kódexre, ott a bíró elnöke adja ki az indítványt az eljárás elindítására. Ez itt egy különleges szituáció, ugyanis ez egy külön döntés a bíróság elnökének az oldaláról. Ami a végrehajtói előírásokat illeti, az eljárások indítását illeti, és itt az igazságügy miniszter 2019-es rendeletére gondolok, a bíróság elnöke írásban felhatalmazhat egy másik személyt, vagy egy bírót arra, hogy elindítsa az eljárást. Így található a szabályzatban, illetve a végrehajtási előírások azt is meghatározzák, hogy ha kétség van, ha kétség merül föl, akkor egy ilyen meghatalmazáshoz a referens az, aki meghatalmazást nyer ennek az eljárásnak az elindításához. Ennek a szabálynak az alkalmazása veszélyes a gyakorlatban, mert ha feltételezünk valamit, az egy olyan jelenség, amit bármikor meg tudunk támadni, hogyha a bíróság elnöke nem adott ki senkinek egy egyértelmű felhatalmazást az eljárás elindítására, akkor ez bizonyos jogi következménnyel jár, mert amikor megjelennek azok a körülmények, hogy egy nem meghatalmazott személy indította el az eljárást, és ugye elévül az adott szabálysértés, tehát 1 év telik el a szabálysértés elkövetésétől, ilyenkor szükség van ilyenkor az ügy elvetésére. Az elévülés ellenére a bíróságok tovább folytatják ezeket az eljárásokat, amelyek ugyanakkor meg a demokratikus jogállammal ellenállnak. Tehát az általános bíróságok szabályzatából indítványoznám az, hogy módosítsuk úgy ezt a szabályzatot, hogy ez a pont ne legyen jelen ebben a szabályzatban, és hogy egyértelműen meghatározzuk az elnök, a bírósági elnök felhatalmazó szerepét. Tekintve, hogy lassan elfogy az időm, ami a bíróságok hatékonyságát, az igazságszolgáltatás hatékonyságát illeti, ez erősen múlik az emberi tényezőn. Ez az emberi tényező az, amelyik megjelenik ugye a bíróságok működésében, az eljárásokban, vagy megjelenik a különböző szabálysértési folyamatokban, erősen befolyásolja az egész eljárás eredményét úgy, hogy egy igazságos ítélet, egy igazságos döntés szülessen meg, mely lezárja az eljárást. Ez biztos, hogy pozitívan befolyásolja az igazságszolgáltatás hatékonyságát. Köszönöm szépen a figyelmet! Nagyon szépen köszönjük professzor asszonynak az előadását. Örülünk, hogy a technikai nehézségek ellenére sikerült önt meghallgatnunk. Köszönjük, hogy elemezte ugye a meghatalmazott pozícióját és a meghatalmazási eljárás elemzését, és ugye az emberi tényező, amit az előadása végén hallottunk, ez nyilván egy olyan tényező lesz, ami a jogalkotó oldalán is megjelenik, és ott bátor döntések jelenhetnek meg a hatályban lévő előírásokról. Akkor beszélhetnénk igazából a kutatásaink hatékonyságáról, hogyha a mi indikációjunk, és itt mindenkire gondolok, minden résztvevőre gondolok, az lenne a legjobb, hogyha a mi következtetéseink politikai döntések lennének az eredményeik, és előttünk az utolsó előadó, ezen a konferencián az utolsó előadás. Szeretném most meginvitálni dr. Erika Csermán, dr. Váradi Csermáné Erikát, a Miskolci Egyetem képviselőjét. Nagyon szépen kérjük akkor az előadást.
Okay, so many thanks. First of all, I would like send you my best wishes and thank you for the possibility to take this presentation only by internet and not personally. First of all, I would like to speak some words about my title, The Possibilities of Prevention-Focused Criminal Justice in the Individualized Society of the 21st Century. The motto of my presentation belongs to the famous writer and philosopher Richard Susskind, who wrote or said that people don't want lawyers, they want a solution to their legal problems. So it means that the answer for my or our questions in connection with the efficiency of criminal justice is very easy. So we can solve the legal problems and no more question and no more problem in connection with the citizens. But the real life isn't so easy. In my presentation, I would like to say some words about the history of criminal justice system, especially in connection the aim of prevention, because according to my opinion, this is one and the best solution if we could analyze this question under the focus of crime prevention. After this, it's very important to say some words about the common point of system-wide approach, because there is common elements and different elements among the system, among the institutions of the criminal justice system. And we know that the importance of society, of security is higher and higher in the last years. We can observe the changes in citizens' attitude, and these give us the answer why is so important to speak about the crime prevention aim. The efficiency of criminal justice is an interesting question in connection with the nowadays results, because if we focus on the effects of information society and the risk society and the globalized society. So we can summarize that the nowadays level of efficiency of criminal justice isn't enough for the citizens. And last, I would like to say some words about the complexity of research and the proposals. So the first question is the social contract and the HU-ENG. The basis of the operation of criminal justice in the modern sense and the existence of state penal power is the social contract by which people renounce part of their nature freedom in favor of the state to protect the remainder of their nature freedom from both external attacks and internal violations. However, under the HU-ENG, a penalty can be imposed only within certain limits, since a penalty which goes beyond the need to safeguard the common good of inherently unfair. The social contract, it's a very important question, not only in the first phases of the modern criminal law history, but in the past 5 years too. However, the punishment was never imposed for self-serving purposes, and we know that the aim and the function of the criminal justice and the aim of punishment depends on the absolute or relative theories, and so we have to see some elements in connection with this. So the absolute theories of punishment based on free will, so indeterminism and on the individual responsibility of the perpetrator, fix the purpose of punishment. This, for example, according to Aristotle, the restoration of violated legal order with the help of punishment. In his view, most people face coercion rather than the fine word, and the punishment rather than the moral duty. So he answered the question in connection with the aim, why have to use punishment, and which is the most important aim of this. But the most part of theories don't focus on the identity of the perpetrator or potential perpetrators. In connection with Aristotle's thoughts, it's very important to say the fact that the amount of penalty applied is based on the principle of arithmetic justice. I would bring here only one of the representatives of absolute theories, Carrara, Francesco Carrara. He was very famous at his time. He spoke about the purpose of punishment, but he wrote that the punishment would be unapplicable even in the absence of all these results. The main purpose of punishment is to restore external order in society. In connection with my research opinion or idea, the relative theories have more important role. The prevention, because of the prevention is at the heart of this idea. But of course, there are several differences among these theories, especially in connection with the method or the way how we could how we could reach this idea in the practice. That there is, for example, Jeremy Bentham's utilitarian approach, or the so-called psychological coercion attitude belongs to Feuerbach, or the very interesting theory of Lombroso, Cesare Lombroso, in connection with the biological determinism. This answers is very differently, but only in connection with the method of this. So it's if we would like to analyze only three important theories in connection with relative theories, I think that Protagoras, Platon, and Seneca is the most important. Why? Because our crime prevention's idea is based has roots from these theories. So, for example, both Protagoras or Platon or Seneca wrote that it's not important to see back, but we have to see in the future if we sentence or punishment, because we couldn't change the past. And so the most important thing is that we change the thinking of the perpetrator or potential perpetrator or the other part of the society. And so all those who have seen the punishment will hate a sin, or at least a larger case with such morning acts. So, and at the last from these three ideas, it's important to say that Seneca isn't includes the this penalty. He said that the this penalty can be used as a last resort to protect the society. But the modern crime prevention idea and theories belongs to Cesare Beccaria, and I think so that the Beccaria theory has some important example for 21st century's criminal justice too. The aim of the punishment, according to Beccaria, could therefore be to prevent the culprit from causing further harm to his fellow citizens, and to deter others from causing similar harm. And it's very important that he wrote that or his opinion, according to his opinion, is the crime a social phenomenon against the other's opinion, who spoke about crime as a legal phenomenon. So he believed that the fight against crime could also be effective, and we could give tools to reach this crime prevention aim. But he wrote about the three elements of the system of criteria, the good and the effective criminal justice, and it's very interesting that he wrote this in the 18th century, but this is true for the 21st century. And this is the inevitability of the punishment. It's very important, especially in connection with the high ratio of latency in the nowadays criminal procedure or criminal acts. And he wrote about the certain quick and proportionate punishment, and so the quickly prosecution is has a special importance in connection with the logical contact, the psychological contact between the criminal act and the punishment. So we can say that Beccaria touched on several aspects of effective justice in the sense of the 21st century. So I think so that this is the one point of view which is important why we could analyze this question from the crime preventional attitude. But there are other answers too. The first is that the criminal justice system is a system which has different institutions, but we know two methods to analyze these: the dynamic or static approach to justice. The dynamic model said that criminal justice is a multi-stage process. Process is very important, that provides a framework for exercising state criminal power against the perpetrator of a specific offense. But the static approach against this don't focus on the process, but on the institutions behind them. And so in this case, we could say that justice can be defined as a sub-system of society. We think maybe that the efficiency elements of the process-focused approach overlap or don't overlap with the success criterion of the system-based approach, but I think so that it's not a good idea because the latter is achieved in the case of more effective protection of society from acts violating the norms. That is, if the enforcement of criminal law does the prevention, control, and suppression of crime can achieve even greater efficiency. So we now state before the fact that criminal justice is a system, but we could analyze several problems in connection with this. That the bodies of this criminal justice system has different structures and governance, and so in connection with this, they have different with their own traditions, socializations, mechanisms, values, or interests, and this is very, very important. So we can say that the institutions are independent, but not from other part of criminal justice, because the connection between these institutions is very impulsive and very strong. So the performance of each body or its change affects the effectiveness of the judiciary as a whole. The quality of the relationship and the cooperation depends on the quality of the interaction between them. And so it means that the interaction between the persons, the experts who work in different institutions is very important in connection with this question. So we can conclude that the priority of ensuring the organizational self-interest and institutional effectiveness of each body. And it means that we have to find some common element which we could analyze or could organize our research. And this common element is the goal of crime prevention. And this is very strong element because the ensuring of public safety is declared the goal of each institutions and the laws that govern its operation. So we know now that from several point of view, this crime prevention was a good solution and was a good choice in connection with this research. But there are other answers in connection with this new 21st century's era. The one is that the needs contact with the needs of risk society. The issue of guaranteeing public security and preventing crime, it's very important in our century, and which is or what is in the background of this situation. That we can see that there are several social, economic, socio psychological changes among the citizens, and this is in connection with streets riots, with immigration, with terrorism or other international crimes, but there are other answers in connection with this, which is important, that the citizens understand that the state couldn't solve the problems in connection with the criminality and couldn't give this high level of security, public security to the citizens. So the social, at the end, in this risk society, the social contract has been rewritten, but it has a new element, and this is that the contract is no longer necessarily the state, but through it on and on its behalf, private companies from the security market. So the citizens give one part of freedom or one part of their human rights to these private companies, and in connection with this, we have we have a lot of questions. The second thing is that we could analyze other changes in I can say each countries of European Union or United States or Australia, for example. The one is the crisis of values, because earlier the rule of law was an important this value, this was a value and was an important value, but in our society, this, for example, this value is erode, and in connection with the globalized world, the relevant the states and the power of the states and the power of national criminal justice, or the power of special values which may belong to the nation and to the country, are becoming less and less relevant. The second is, or in connection with this, we could say that instead of states, the power belong the global economic actors from outside, for example, or the information and communication technologies firms, and so without civil control or without other guarantee rules. The first thing is, and in connection with this, the very famous philosophers Ludwig Wittgenstein testified that by our time the morality has ceased to be a code of society. Instead, we have outsourced to the market and to the states and the states. And we have other problems in the countries in connection with moral, religious, or political conflicts. And so at the end, we can observe that the trust in institutions is constantly declining. And parallel with this, we could name the new elements of successful orienting in the information society. And one of these 4C is the critical thinking. And the critical thinking is very important in connection with this new society, but the critical thinking or in connection with this, we have new conflicts against the state. Not only this is important if we would like to know more about the efficiency of criminal justice, but the so-called individualistic approach, because this is or cause very important change in society, and altruism, for example, isn't more interesting question, and the earlier we are all together is changed to I am free, and I am free to choose anything. And for example, Fukuyama wrote in 2 or 3 years ago a very interesting book in connection with these processes, and he asked that could we find any way, only one thing or one idea which is important for all citizens in the United States, or could we speak about one nation if the so important processes characterize the USA society, and this is a very special situation. But I think that these ideas travel or flight to European Union countries too. And parallel with this, these new approaches, this egoistic approach caused I can see so that the feeling of alone, and the digital world and the social media and the internet is reinforced this feeling. So at the end,
dear doctor, I'm so sorry that I interrupt you, but your colleagues from Hungary don't want to stay in Warsaw during the weekend. So we have to end.
Excuse me.
If you can go to the conclusion, please.
Yes, of course. I spoke about the new generations and the needs of these generations and the problems in connection with the understand the criminal procedure, the communication, and the significant conclusion in connection with this, and this is my research, and I had several proposals or thought in connection with this because I have to find the answers not only in connection with the dynamic approach of criminal justice, but the statistic approach too, and this is in a wide in a society level or on a society level, on members of societies level have to analyze, and of course that is my research points. So excuse me once more, and thank you the possibility to take part this presentation, to take part this conference and take this presentation.
Thank you very much. Kosodom, thank you very much, dear doctor. Szanowni Państwo, tak jak wspomniałem, to było ostatnie wystąpienie nie tylko tej sesji, ale konferencji.
Hölgyeim és uraim, ahogy említettem, ez volt az utolsó előadásunk a konferencia keretén belül, és engedjék meg, hogy szeretném megköszönni az előadóknak, a jelenlévőknek és mindenkinek, aki online bekapcsolódott, tekintve, hogy egy különleges pandémia helyzet uralkodik Lengyelországban és Magyarországon. Szeretném megköszönni mindenkinek ezt a nagyszerű intellektuális kalandot, ezt az intellektuális utazást, amit ez a platform adott nekünk, ez a magyar-lengyel platform, és havonta az irodámból hallgattam az önök előadásait, és hát nem tagadom, hogy nem csak az alkotmányjoggal kapcsolatosak voltak érdekesek, hanem mind a 4 csoport munkája, úgy gondolom, olyan gyümölcsöket hozott, ami nagyon-nagyon érdekes intellektuális kaland volt számunkra. És az a csendes remény van bennem, de szeretném, ha ez elhangzana, hogy az önök műve, amely nem sokára materializálódni fog, 4 monográfia formájában, és ezek a fellépések, az online fellépések is meg fognak természetesen jelenni, és remélem, hogy ez mind ott lesz a jogalkotók asztalán, és el fogja őket érni, és reméljük, hogy ezekkel az ötletekkel, ezekkel a javaslatokkal dolgozni fognak, és a gyakorlatban is ennek a gyümölcse új törvény módosításokban, új törvényalkotó folyamatokban fog megjelenni, ahhoz, hogy Lengyelországban hatékonyabban tudjuk az igazságszolgáltatást működtetni, és akárhogy meg tudjuk változtatni a megfelelő sztenderdek alapján az alkotmányt. Az volt a lényeg, hogy ez ne csak egy publikáció legyen, amit utána félreteszünk egy polcon, egy könyvtárban, itt az egyetemek könyvtáraiban, akikkel együtt működünk, hanem az volt a lényeg, hogy ez egy gyakorlati munka legyen, és hogy a munkánk gyümölcse élő joggá változtasson, hogy ne csak a law in the books-ot gyakoroljuk, hanem law in the action-t is. Még egyszer köszönöm mindenkinek, és bízom benne, hogy a jövőben is találkozni fogunk különböző tudományos területeken. Most egy 1 perces technikai szünetet tartunk, és utána pedig megkérem az intézet igazgatóját, hogy adja át a résztvevőknek a tanúsítványokat. Köszönöm szépen! Tisztelt résztvevők, itt az ideje annak, amiről tegnap beszéltem, ez a rossz hír, mert lezártuk a projektet gyakorlatilag, de van egy jó hírem is, amiről szintén beszéltem tegnap, hogy folytatnunk kell ezt a projektet, és szélesítenünk kell ezt a projektet. Még egyszer köszönöm mindenkinek a munkáját, nagyon sok értékes tapasztalatot adtatok nekünk. Minden, ami a legjobb, átadtátok nekünk. Folytatjuk ezt a munkát, tudjuk, hogy mik a céljaink, tudjuk, hogy mit szeretnénk elérni, milyen álmokat. És ma az utolsó aktus, találkozónk utolsó aktusa, erre a találkozóra tanúsítványokat készítettünk, és minden résztvevő fogni kap egy ilyen oklevelet emlékként, de hát főleg emlékként. De hogy tudjuk hogy ugyanakkor népszerűsíteni ezt a projektet, úgyhogy ezért kérem, hogy sorban a résztvevők, véletlenszerű a sorrend, úgyhogy ebből ne vonjunk le következtetéseket, és akkor fel fogjuk olvasni sorban a neveket, és kérem, hogy vegyük át a dokumentumot.
Pani doktor Katarzyna Zombory. Dr. Iris Horvat. Profesor Marta Osuchowska. Dr. Noemi Shuri. Profesor Aleksandra Syryt. Profesor Adam Rikser. Profesor Emot Veres. Dr. Ondras Mazi. Profesor Barbara Janusz Pol. Tak, dziękujemy bardzo. Proszę Państwa, osoby, których nie ma...
Nagyon szépen köszönjük. Azok, akik nincsenek jelen ma itt velünk, postán el fogjuk küldeni az okleveleket. És akkor mindenkit most egy ebédre szeretnénk invitálni.